moving right along. The winning in the Ontario's highest court, if you haven't heard already, contrary to perhaps what the newspaper has been spinning you, there's been a landmark decision. I would like to take credit for it. Unfortunately, I have to bestow that credit on my lawyer, Francis Thatcher, who was able to fight this in 2 times in the Superior Court and win, and then take it to the highest court in Ontario, and Oz and his crew have lost. They're 4-time losers. They've lost before council, they've lost twice in Superior Court, and now they've lost in the Court of Appeals, which is the highest court of Ontario. To just go to the appeals court cost you about $35,000, and my lawyer was astounded that they had not even filed for costs at this point in time, and now they're past the deadline. And he said that money seems to be no issue with these people, Mr. Ken Odds and his fellow travelers. What this decision does is, when council decided not to, on reasonable grounds or unreasonable grounds, not to audit me, and that was largely due to the work of Councillor Mary Roy, who's here tonight, who's always says she's saving my butt. Absolutely the hardest working councillor, okay? And she drives all of us mad because she's always doing all the work and saying we've got to do it, and then she drags us along. But when they decided not to audit me in council, and I think the vote was 7-5, then what Odds and Company should have done was challenge the council decision, and that was in the agenda materials of the that night when the audit was done, and that was the opinion of the city solicitor. The only thing you could do is you can't go after an individual councillor any more than you could if we chose to go to a dual or single source. You had to challenge the council decision. I firmly believe that they had some inside information, because if they were, I mean, you have to be an idiot or less than a lawyer to know, after reading these materials, the only thing you could do is challenge council's decision. But if they were to challenge council's decision in me, then the corporation would have to protect the council decision and defend it, right? So if they're defending their decision, how could they not defend me? What they chose to do, honest at all, was just to attack Councillor Santa as opposed to the council decision. And if you look at the legal opinion you have in front of you, which is supposed to be stamped confidential, but it isn't, and that's this one here, and you go through it. This is the opinion of the city solicitor, Alan D. McKittrick, and I don't want to take you through the whole thing. There's some of the parts I've underlined so you can read, but if you go to page 3, section E, it says the legal proceedings, at least in part, are not good faith proceedings. And he continues to go through there, and this is good reading for you tonight when you go to sleep. I know I always read it. And it talks about how council should have defended their decision. Who would ever want to run for council? Any one of you want to run for council, knowing that somebody could sue you and drag you through the courts to the tune of $201,000, which is the cost just for this simple Municipal Elections Act application. On page 5, section number 27, I'm just going to give you some of the highlights. He said the city did not intervene, and therefore, in our view, got a free ride when Councillor Santa himself successfully defended the challenge. At that point in time, it was not himself, it was Francis Thatcher with me. I did act as my own attorney for 7 months, and that's another ride we'll talk about sometime. So, by winning in the Court of Appeals now, this is a monumental decision, because if anybody, anywhere in the province of Ontario, wants to challenge a councillor, okay, he can save $201,000 if he goes to the internet and prints off the Court of Appeals decision. He can just walk up to the judge and say, before we go any further, I want you to read this.